Hello friends, a very warm welcome to UnSarkari. I am Vikas Bhardwaj, taking up our series of complex topics and also making sure that you understand them in a clear-cut manner so that you can get a good score in the examination. Today we are going to have constitutional comparison of India and South Africa. So what first comes to our mind? Those foundational values which are reflecting at the base of both India and South Africa. Just close your eyes, try to think and understand that in India when it became republic, justice, liberty, equality, fraternity, which are at the soul of preamble, they reflected our vision. Whereas in South Africa, you have to remember the year 1996, human dignity, equality, and see, human dignity is coming up first. Freedom, non-racialism, and non-sexism, they are coming up. That means both the countries, they are having a different past and they are seeking answers which are the best and sustainable for their citizens. So what we can critically understand that India is emphasizing a unity and diversity, whereas South Africa is emphasizing transformative justice after apartheid. Apartheid, we know, the policy of racial segregation, the policy of division of resources, people, minds, and everyone on the basis of black and white. Let's see structure of government. In India, we know parliamentary democracy, quasi-federal structure is there with a strong center. We have discussed this in our previous lectures also. Whereas in South Africa, it is parliamentary democracy, it is unitary, but provincial autonomy is a significant feature. That means India balances federalism with central dominance, whereas South Africa is balancing the structure with decentralized provinces. Let's see rights framework. We will see in details also. In India, fundamental rights are there. That is, civil and political rights are reflected by that, and directive principles of state policy, which reflect the socio-economic perspective, which are non-justiciable. In South Africa, there is Bill of Rights. That is, civil, political, socio-economic rights. They are enforceable. A little difference. So for prelims also it is very important. South Africa socio-economic rights are justiciable. India's are directive but not justiciable. When we see judiciary, then Supreme Court, High Court, and judicial review. In fact, PIL tradition is India's innovation, whereas South Africa is having constitutional court as apex guardian, strong role in enforcing socio-economic rights. So that means South Africa is pioneering transformating constitutionalism. We will be revising it soon. So transformative constitutionalism reflects gradual expansion of rights through judicial activism. When we see India, that is privacy, environment, education. In fact, we will just see the cases also in some moments. Whereas in South Africa, explicit constitutional commitment to transformation. What is explicit constitutional commitment? That is housing, health, equality, roti, kapda, makan, and all those kind of things which India also believes in sincerely. That means South Africa embeds transformation in text, whereas India is relying on interpretation. Definitely we agree with this, but both are moving in a positive direction. So what are the historical injustices? In India, it is abolition of untouchability. Affirmative action is reflected through reservations, whereas in South Africa, post-apartheid redress is reflected through land reforms and black economic empowerment. That is affirmative action for the black communities, for the tribals. They must be given home, they must be given employment, they must be given opportunity for education and so forth. So these are the tools of social engineering. But South Africa is obviously more explicit about redistributive justice because they have suffered directly a lot till 1990s. Now, when we see pluralism and democratic consolidation, then India is a multi-linguistic, multi-religious, plural society having great federal, accommodation and also asymmetry. Whereas in South Africa, it is racial, ethnic pluralism, reconciliation through constitutional values is important, and India's challenge is managing diversity through federalism, whereas South Africa's challenge is healing apartheid divisions through rights and dignity. Now, when we say how South Africa is negotiating transition from apartheid, we say it because the society, or you can say constitutional journey of South Africa was fundamentally different from India. It was shaped by negotiated, okay, negotiated is a key word, end of apartheid, and a commitment to inclusivity and reconciliation. Three keywords. Now, the process began in 1993 interim constitution, which set the stage for first democratic elections in 1994 and the establishment of Constituent Assembly. Now, India actually witnessed direct elections. Role of universal suffrage, all adults were allowed to vote and operated in the context of intense public engagement and negotiations. There was a great role played by the Constituent Assembly. There was learning from the British rule and also constitution development. So, if we see the preamble, as I just wanted to make you feel, the 1996 preamble is explicit in its transformative ambition. It is recognizing historical injustices. The preamble is addressing the legacy of apartheid, democratic values, and social justice, that is, equality, dignity, and human rights. And it is also saying belongs to all who will live in it, united in our diversity. So what we can say, India's preamble, like South African preamble, they both reflect aspirations, they both reflect transformation. But South Africa is definitely more explicit in acknowledging past wrongs and the need for healing, whereas India is revolutionary with time. We know we will do a separate lecture already in a different series where we will see that how interpretation of even preamble has been evolved, and it is very important for prelims also. So let's see cooperative governance in a quasi-federal system in South Africa. Why? Because in South Africa, which is a unitary state with federal features, it is a system of cooperative governance. President is there. President is the both head of the state and government. There is cabinet. There is a bicameral parliament, National Assembly, and the National Council of Provinces. Judiciary is there. What we can say is the constitutional court at the apex. Federal features are there. What we are the feature, three spheres of the government: national, provincial. There are 9 provinces and also local, that is municipalities. Provinces have legislatures and executives with powers over certain areas, not all the areas, schedule 4 and 5. And when we see unitary features, then constitution is supreme, national law prevails over provincial laws in case of conflict, national government can intervene in provincial matters under certain conditions, and emphasis on intergovernmental cooperation rather than strict separation of powers. India is also not having strict separation of power, it is having separation of powers. So what we can observe: India, federal, that is Union of States, unitary with federal features. Executive, president is here as a ceremonial head, whereas PM is the real head. President is both head of the state and government. Bicameral, as I just told you. Judiciary, Supreme Court at the apex. Federalism, strong center, state with powers, cooperative governance, and local panchayat and municipalities, 73rd and 74th Amendment, whereas municipalities, metropolitan, and districts are there. So that means India's federalism is characterized by strong center and significantly unitary features, reflecting concerns about national unity and diversity management, a recurring theme and a basic idea at the base of even our civil services. South Africa's model was formally unitary. It is a formally unitary. It incorporates federal elements, emphasizes cooperation and subsidiarity, but it is reflecting the needs for reconciliation and equitable debate and also development. That means if I see federal structure, India is a quasi-federal, strong center, cooperative, quasi-federal. Division of powers, union, state, concurrent, schedule as I just told you. Residuary power with the center, here it is the national government. And then interstate council and zonal councils are there in India. You must remember even articles for the prelims, and president's council and IGR framework is also there. Fiscal federalism, finance commission and GST council is there in case of India. Division of revenue act and fiscal commission, you don't need to go into details, it is there in South Africa. That means both the system, that is Indian and South African, they seek to balance unity and diversity. Indian model is more centralized, and then South African is more cooperative in nature. And then you can say it is promoting reconciliation, equitable development, but it is facing challenges of capacity and central dominance. Now, when we see India's directory principles of state policy and also judicial expansion, then we know the part 4 of the constitution: right to work, education, public assistance, just and humane condition of work, maternity relief, living wage, and improvement of public health. Must remember this by heart. So not directly enforceable, but courts have interpreted Article 21 expensively. Let's see some cases which you must remember. Menka Gandhi versus Union of India, it went on to expand Article 21 to include substantive due process. Tellis versus Bombay Municipal Corporation, right of livelihood, right to livelihood as a right as a part of right to life. Krishnan versus state of Andhra Pradesh, right to education as fundamental right. Paschim Banga Khet Mazdoor Samiti versus state of Bengal 1996, right to health. And MC Mehta versus Union of India, right to clean environment. Please remember these cases. Please remember the years. You can always get in the prelims also. Whereas South Africa, right to access to adequate housing, care, food, water, education, and right to an environment not harmful to health and well-being. That means rights are subject to progressive realization within available resources. But obviously, court can always require the state to take reasonable measures. That means South Africa approach is more robust. Courts are empowered to hold the state accountable for progressive realization of socioeconomic rights. India's model is relying on judicial innovation and activism, and it is also making a lot of gains. We have PIL, we have separation of powers, we have different means and ways of enforceability. So they both are little different. Now, when we are talking about judiciary, let's compare once more. In case of India, judicial review, yes, there is there. Basic structure doctrine is there. Here, constitutional supremacy is there. Appointment is through collegial system. Appointment is through Judicial Service Commission. It is having a transformative role, definitely transformative role. Judicial activism, PIL, explicitly transformative, and it is value based. And judicial expansion and PIL is there, and it is direct enforcement and structural orders. That means when we are seeking about the key cases for comparative analysis, as we just said, then we have already seen these cases that they are making so much difference. That means both democracies and both powers are moving ahead in this 21st century, playing a very, very important role, both not only in the international arena, but also in their respective countries. So key similarities, what we will say, transformative ambition, both the constitutions are designed to transform society, redress historical injustices, promote substantive equality. Comprehensive rights protection both guarantee wide range of rights, including civil, political, and socio-economic rights. Judicial independence both have powerful, independent judiciary, play central role. Commitment to pluralism. So you can always note down these keywords. Now let's see differences. Scope and enforceability of rights is not same in both the countries. South Africa's Bill of Rights is broader and it is more directly enforceable, especially socio-economic rights. India is a federal union with strong center. South Africa is a unitary state with federal features and cooperative governance. South Africa's approach is more explicit as far as affirmative action is concerned because it wants to reflect upon the urgency of redressing apartheid's wrongs. South Africa's judicial appointment process is more transparent because we say that they have a judicial commission, whereas India is more insular in some scholars words, and it is judicially controlled. That is true, but then we have discussed in our one of the other lectures that how collegium system is one of the robust systems in India. Environmental rights, South Africa's constitution is explicit, India's relies on judicial interpretation. South Africa's are more rigorous and participatory. India's are flexible but safeguarded by judicial review. That means in case of India also we say it is only because of the judicial independence, judicial proactiveness for making sure that our constitution is evolving and our constitution is a living document that our judiciary has actually helped not only executive but also other sectors of life to grow and move forward in a positive direction. So what lessons and best practices we can say? Strong constitutional foundations, yes. Flexibility and adaptation, that is true for both of them, and they are adaptable also. Judicial independence and accountability, it is there, both of them. Institutionalized coordination, it is there. And then continuous evolution, both the countries are also moving forward with that. So what we can conclude, that they are monuments to the power of law to shape society. You can write in essay, you can write in ethics also. They shared aspirations for justice. They reflect differences due to unique history and challenges they have faced, and opportunities are there for their societies to move forward. Valuable lessons for constitutional design, rights protection, and the pursuit of social transformation for the rest of the world also. But what is true? The true is that constitutional promises are not self-executing. They require vigilant courts, responsive governments, active civil society, engaged citizenry. These words you must be writing in your main answer. Otherwise, very difficult to crack through. The journey from constitutional text to lived reality is ongoing, marked by struggle, adaptation, and hope. That is where both India and South Africa, they both inspire, and they are actually reflecting that you come to their standard to the whole world. So thank you very much for being with me in this lecture and thereby helping all of us to solve and discuss one of the concepts which is indirectly and directly very important for your preparation. Thank you very much. Do like, share, subscribe, and definitely join our courses for success.